Hi everyone, welcome back to Mitra and His Standing. Today I will be taking you through key points on negotiating debentures when acting for lenders, particularly in the context of distressed situations. We'll go through a standard form lender side debenture and discuss the key negotiating points and things to bear in mind when drafting and negotiating debentures and other English law security documents in this context. In distressed situations, lenders have the opportunity to push for security terms that are much more robust than what is typical on a European leveraged finance transaction. When the borrower does not have a strong negotiating position, you can and should be significantly more aggressive in what you ask for. And before we dive into the detail, always begin by checking what the principal finance documents have to say about the scope and the terms of the security. If there are agreed security principles on that transaction, you should start there. If not, look for any other provisions in a facility agreement or credit agreement which specify what security will be taken and upon what terms. Next, work out which document you should use as a reference for definitions. On English law or European-led leveraged financings, it would usually be the intercreditor agreement, which is designed to remain in place while other finance documents might be amended, supplemented, or replaced. However, for U.S. deals, there may be no intercreditor, even if there is. Most of the key definitions may be in the credit agreement. On enforcement trigger, a key concept in the debenture is the moment where the security agent is entitled to begin enforcement and when control over the secured assets therefore passes from the chargers to the security agent. On European deals, this would usually be a declared default or acceleration event, meaning that an event of default has occurred and the requisite directors have voted to accelerate under the intercreditor agreement or facilities agreement. However, on U.S. deals, the market standard is that enforcement of security is permitted immediately upon the occurrence of an event of default. So the debenture should follow the position in the principal finance documents on the deal. If the lenders are in a strong negotiating position, they may want to argue that the security agent should have the discretion to exercise some or all ancillary enforcement rights before the enforcement trigger has occurred. For example, to exercise the power of attorney to take control over some key secured assets or to give notice to counterparties where day one notice is not required. And the standard form usually provides that enforcement powers shall be immediately exercisable at any time after a declared default has occurred. Next, on the type and scope of security, lenders would want fixed or specific security over as many assets as possible, whether by way of mortgage, by charge, or assignment, in order to achieve priority over subsequent creditors and floating charge holders. However, this needs to be balanced against the time and the cost involved in taking the control and the professional steps to achieve a fixed charge over each class of assets, and whether this is proportionate to the credit risk on the particular deal, as well as the practicality of allowing the borrower to run its business and generate cash to repay the debts. Generally, the standard form creates security by way of first legal mortgage over all real estate in England and Wales, and by way of first charge over shares, block accounts, operating accounts, intellectual property, plants and machinery, and other debts, goodwill and uncalled capital, and the assigned agreements. Critically, if The floating charge is a qualifying floating charge over all or substantially all of the assets and undertaking of a chargeor. The security agent will be entitled to appoint an administrator in respect of that chargeor. For this reason, the floating charge in our form, in the standard form, expressly provides that Schedule B1 to the Insolvency Act 1986 shall apply. And when acting for the lenders, you should omit any exclusion from the floating charge that might prevent it from being a QFC, qualifying floating charge. Next, on crystallization and control of assets. When a floating charge crystallizes, whether by notice or by operation of law, it operates as if it were a fixed charge, and control of the assets passes to the security agent. If the security agent has the discretion to crystallize the floating charge prior to the agreed enforcement trigger, it gives its lenders a potential lever to force the borrower into restructuring discussions. And usually the standard form gives the security agent the power to convert the floating charge into a fixed charge by written notice where an event of default or declared default has occurred, or where any material assets charged under the floating charge is in danger of being seized or is otherwise in jeopardy. Crystallizing by notice upon an event of default is very lender-friendly, since it can turn off, as you can imagine, it can turn off the borrower's cash flow and effectively force a restructuring. The floating charge would also automatically crystallize if any third party levies distress, attachment, execution or other legal process against any secured assets. If any chargeor creates unauthorized security, or if an administrator is appointed. Next up, on bank accounts, the spectrum test to achieve a fixed charge over a bank account requires blocking the accounts completely from the outset, which is incompatible with allowing borrowers to run their business on most leveraged financial transactions. However, in distress situations, a subset of accounts may be blocked in order to protect key cash flow, for example, when required to be applied in mandatory prepayment. So generally, the standard form distinguishes between blocked accounts and operating accounts and charges them separately in order to avoid polluting the fixed charge over the blocked accounts with a charge that will in practice take effect as floating. Even where a fixed charge is not possible over operating accounts, giving notice to the account bank of the existence of the security can still assist with priority over other secured creditors. Therefore, the timing of the delivery of such notice is an important prevention step for lenders, and on distressed deals, lenders should push to have notice delivered on day one. And the obligation to obtain an acknowledgement is often difficult to satisfy in practice, since accounts banks are not involved in the deal and they have very little incentive to cooperate. And they've got so many bank account holders, why would they cooperate? They have very little incentive to do that. So well-advised borrowers would often request a compromise position whereby they only have to use reasonable efforts for a set period of time. Typically, it's 20 business days or 30 business days to obtain such acknowledgement, after which the obligation collapses. So generally, the form includes for a very lender-friendly form, it would include a 15 business day deadline for serving account notices with a further 20 business days to obtain acknowledgement. Next, on the shares and the financial collateral regulations, the mechanisms for giving perfected share security over English company is not controversial. Delivery of original share certificates and signed stock or share transfer form with the transferee left blank. Negotiation tends to focus on companies within the group this obligation applies to, and the most lender-friendly option would be all subsidiaries incorporated in, say for example, in England, Wales, but some agreed security principles will limit it to those subsidiaries which are obligors or material subsidiaries or material companies. And the other key commercial point on shares, because they constitute financial collateral for the purpose of financial collateral regulations, is the agreed method of valuing the shares for the purpose of appropriation on enforcement. So borrowers will seek a cumbersome valuation process, and lenders will want to allow the security agent more discretion to facilitate the speedy enforcement. So for a very lender-friendly standard form, it provides that the value shall be the market value as determined by the security agent in a commercially reasonable manner, including by way of an independent valuation. This gives the security agent broad discretion. Borrowers with negotiating power will usually push to require a fair value option from independent third-party advisors. Next up, we've got intellectual property. So intellectual property, IP, may be a key asset on some leveraged finance deals, most commonly for software businesses or certain healthcare or pharmaceutical companies where their key product is IP protected. In such cases, a bespoke obligation relating to the registration and perfection requirements, as well as the provision of information and schedules relating to the company's IP, will need to be agreed. It is sensible to involve specialist IP lawyers as early as possible where this is the case. Registering security interests on IP registers can be costly and time-consuming. So for many deals, the obligation to do so is postponed until after the occurrence of a default. And for lender-friendly form, it usually follows this approach. But if IP is a particularly important or material asset for the particular business, lenders may wish to require day one registration, at least in respect of the key or the material IP. Next, on assigned agreements and insurance. The scope of assigned agreements will depend on the deal. An acquisition agreement is only relevant on a new acquisition financing. The inclusion of intra-group debts should be uncontroversial. Check that the definition is broad enough to capture all such debts when acting on the lender side. The most heavily negotiated point may be the specific inclusion of insurance policies in the assignment. Depending on the type of business, that is the importance of real estate or other physical assets, and on the negotiating power of the parties, lenders may want to insist on day one notice being served on insurers, and in some cases, acknowledgement sought. And even more, if there is a spectrum, even more lender-friendly position is for the security agent to be named as loss payee or co-insured on the insurance policies. But this is unusual outside the context of an asset-based financing deal. In a lender-friendly form, it generally allows the security agent to require this endorsement following the occurrence of an event of default. And last but not least, the boilerplate provisions and U.S. deals consideration. Boilerplate provisions in security documents should track any corresponding provisions in the principal finance document. Often it will be unnecessary to duplicate provisions such as notice clauses and currency conversion clauses, which are already in the facilities agreement or in the intercreditor agreement and expressed to cover all of the finance documents. However, one point to note is that on U.S. deals, the debenture may be the only document governed by English law, and in those cases there are certain provisions which is preferable for lenders to include in the debenture rather than relying on the New York law or other law provisions in an intercreditor agreement, in a credit agreement, or in a U.S. credit agreement. Two essentials to note. First, waiver of defenses. On English law deals, this leaves in the waiver of defenses leaves in the facilities agreement guarantee clause. On U.S. deals, it probably doesn't exist. So include a comprehensive waiver in the debenture itself when preparing a U.S. English law debenture. Second is about the set-off. The security agent needs an express English law right of set-off. If there is no English law principal finance document containing one, it must be in the debenture in order to protect the lender's rights. Do not assume that you are covered. So to conclude, when negotiating debentures for lenders in distressed situations, start with the principal finance documents and any agreed security principles. Then consider the enforcement trigger carefully. This is the key moment when control passes to the security agent. And then push for fixed security over as many assets as possible, but ensure that the floating charge remains a qualifying floating charge to preserve the right to appoint an administrator. On account banks, distinguish between blocked and operating accounts to preserve fixed charge status. On distressed deals, push for day one notice to account banks, issuers, and other counterparties. Pay attention to evaluation mechanics for financial collateral. And on U.S. deals, include English law waiver of defenses and set of provisions in the debenture. So that's all for this video. If you enjoyed, make sure to comment, like, and subscribe. I'll see you next one.